everyone, and thank you for joining us this afternoon for the second session in our fall and winter webinar series. Today, we're going to discuss the 2025 legislative outlook and what your company should keep an eye on in the new year. If you've joined us in the past, you know I'm Sophie Dietrich, the HR professional for the Compliance Center team here at Wagner, Falconer, and Judd. Our team is dedicated to supporting your business as you navigate any human resource and employment law questions. And as always, we're very happy to have you here today. I'll share some quick housekeeping items before we get started. Please send your questions via the chat option at the bottom of your window. We should have time to address questions as they come in, so send them our way as you think of them. And also, so you are aware, this webinar is being recorded to share with those who could not attend live. We will be sharing a link to the recording afterwards for your reference too. So with those items covered, let me introduce you to our presenter, Janelle Stanton. If you're a regular attendee of our webinars, you know that Janelle is a senior associate with the employment law team here at Wagner, Falconer, and Judd, and she brings over 9 years of employment law and business litigation experience to the table and dedicates much of her practice to counseling business leaders like yourselves on maintaining compliance with all those federal, state, and local laws. You'll always hear me say that she's our favorite thought partner to have around. And so we're very excited to have her share with us today. And again, thank you everyone for joining. And with that, I'll hand things over to Janelle.
All right, perfect. Thank you so much, Sophie. And very hopeful today that the technology does what it needs to do. So sorry again for all of the snafus last month. We are going to be recording the webinar this week to get that recording out to you guys. To address those lingering ESST pieces that we were presenting on last month. So we've got a pretty packed agenda today. So we've got a lot that we're going to talk about. We are going to discuss some of the stuff that's been going on at the federal agency level with the Federal Trade Commission, the Department of Labor, the National Labor Relations Board, and OSHA. So we'll get started with that. And then we're going to wrap up with everybody's favorite auctioneer style state law update. So everything that you need to know going into 2025 as far as recent legislative updates. So like I said, got a lot to cover, but as Sophie said, feel free to throw out those questions anytime. We may not have time at the end to get to those. So if we're not able to get to your question, you guys can always reach out to us. Chris Kelly's email address is on the last slide. So if you didn't get a chance to have your question answered or you want to follow up, always feel free to do that as well. Okay, so the Federal Trade Commission. For those of you who've been in our webinars this year, you probably know that the FTC had a non-compete ban in that was set to take effect on September 4th, 2024. This was a very broad non-compete ban, and it had some pretty far-reaching provisions in it that required companies to go back and notify any even former employees that were subject to non-competes. It was very broad as far as the types of non-competes that were banned. Well, Texas federal court judge blocked that on August 20th. So what that means for companies is there is no need to comply with the FTC's non-compete rule. Now, what does that mean for future purposes, though? The FTC may appeal, and I think it was maybe more likely that they would have appealed had the election not gone the way that it did. With a second Trump administration, it is potentially less likely that the FTC is going to appeal this ruling. So do still continue to monitor those developments. I also do want to put a plug in here about the NLRB, the National Labor Relations Board. I don't know that we've had a lot of opportunity to discuss the NLRB in our webinar series that we've had to date. Just as a sort of very basic primer level, the National Labor Relations Act, which is enforced by the National Labor Relations Board, is typically going to be something that unionized employers are worried about because it deals with union elections, it deals with, collective bargaining agreements and those types of things. So a lot of employers sort of put it kind of horse blinders to the National Labor Relations Act and the board because they think it only applies to unionized employers. However, there are a few sections of the National Labor Relations Act that apply to non-union employers as well. And a couple of those we're going to talk about today. The first is this: the board has issued, the General Counsel Abruzzo issued a memo a while back stating that they were going to be putting non-compete agreements under the microscope and that they consider non-competes to be an unfair labor practice. And what that means is that if an employee is subject to an unfair non-compete and it damages them in any way, or if an employer tries to enforce an overly broad or restrictive non-compete, the board could go after a company and charge them with engaging in unfair labor practices. And that used to be a bit of a sort of toothless threat. There wasn't a ton that would happen. They kind of slap you on the wrist and move on. However, Jennifer Abruzzo, again, this fall, or earlier this fall, has proposed new remedies for employees who are harmed by these types of non-compete agreements in an effort to resolve the financial impact of that non-compete. And you guys, this is very far reaching. So it's no longer enough for your company to just rescind the overly broad non-compete. They're also going to look at, did the employee take a lower paying position to not violate the non-compete? Did they move? Did they relocate and have relocation costs to move outside of the geographic scope of your non-compete? Did they get additional training or education to qualify for a position that wasn't covered by the non-compete? All of those financial harms that an employee might be subjected to because of the overbroad non-compete could be ordered to be paid by the employer. And that could get expensive depending on the circumstances. But the even more consequential piece of this ruling is that if an employer does go through the process to try to enforce a non-compete, if they bring legal action and the general counsel determines that the non-compete was unlawful, then the board can they can dismiss the matter and order the employer to pay the employee's legal fees and costs that they incurred to defend against that action. And again, if you've been in any of my webinars, you know that usually what I'm telling you is that lawyers are expensive, and that probably the most expensive part of this remedy is that attorney's fees provision. So even though the FTC non-compete ban is struck down, even though the federal government makeup is likely to change, still be wary of the NLRB and what that means for your company. The other thing to think about is states. So this map, this was effective as of April 24th. So there could be some changes to this. But essentially, this map shows you where there are either full bans of various types of income restrictions, other restrictions, or no restrictions at all. So we've got 4 states that have full bans on non-competes. It's California, North Dakota, Minnesota, and Oklahoma. Interesting state combos there. And then, of course, the ones that you would probably expect to see income restrictions on are highlighted in that lighter blue color. Those states all have varying levels of pay that an employee has to earn in order to be governed by a non-compete agreement. Some of them can be as low as $13 an hour. Some of them are much higher. But just be aware that there's income restrictions in Washington, Oregon, Virginia, Maine, Illinois. The sort of purple shade, there's other restrictions. And most of those other restrictions are that the non-compete has to be reasonable. So that's a very common issue in those states. Non-competes are still allowed, but probably still disfavored. And as a sort of, this is something that they've been disfavored for a while now because unfortunately employers have abused them for a long time. States in the gray do not have any restrictions. So you can note this for future purposes, but I would say as the federal government now swings more conservative and Republican, I think states will pick that back up and potentially start passing more of these non-compete bans. All right. Are you ready for the ultimate ping pong situation here? So my goodness, this Department of Labor salary threshold increase. Okay, so here's what was going to happen. What was going to happen was that as of July 1st, the salary threshold for exempt employees went up to $844 per week. And so that went into effect on July 1st. Companies in most cases raised salaries up to that $844 level. And then we were, so it went through. We were like, all right, this is what we're dealing with now. We were all sort of waiting to see what was going to happen with January 1st. Was the salary going to make even another leap up to $11.28 per week? There was potential that would get struck down, but maybe that the July 1st increase was going to stay. Of course, because we're talking about it, I think now, okay, both got tossed. So not only is the January 1st, 2025 increase tossed, but the one that was effective July 1st of 2024 has now been overturned. It's been invalidated by this Texas federal court judge. And again, very similar, Texas striking down a lot of these things. It is proving to be a much more employer-friendly jurisdiction. So I think this is just going to keep happening in Texas. But essentially, in November, this federal judge, they blocked the 2024 rule, which encompasses both July and January increases. And the court here ruled that the Department of Labor had exceeded its rulemaking authority by focusing only on salary and not employee duties for exemption. So they were like, there's 3 parts to this exempt employee test: salary basis, duties, and salary threshold. And what the court's reasoning was that by continuing to increase this salary threshold, the Department of Labor was making, the salary threshold be sort of this top level test, and the salary basis and the duties test was almost irrelevant. Whether I agree with that or not, that is the position that the court here took in their analysis. And so now future phases of the rule, including any automatic increases, those were also invalidated. And so now we're back to that, and I didn't put it in here. We're back to that salary of $36,000, I believe. I can't remember what it is. Maybe Sophie can look it up and throw it in the chat, but I believe it's $684 per week, or something like 36,000. So it goes back to what it had been before. What does this mean for companies? My guess is that if you've got exempt employees, that you probably did go through the process of changing exempt employees' pay, increasing it so that you could maintain that exemption. Well, technically, what you can do is you can roll back those increases. You can't recover any past amounts of pay, but you could roll it back and you could take back any of those pay increases that you did provide. Now, there's some pretty severe consequences to that in, morale and trust and those types of, feelings issues. So whether you decide to roll back those increases or not is a pretty significant business decision to make, but would be supported by, what the status of the law is currently. So, I think next steps, think about what you're going to do. Are you going to roll back those salaries? Are you just going to lump it and say, okay, well, we've already increased it. Our budget, we can afford it. It's fine. We're just going to rock and roll with it. Or are you going to say, yes, woo, off the hook. And we could not afford this. And we weren't really sure how we were going to do it. And you're going to roll it back. Think about your messaging, think about how you do that and go about making those changes. Now, I would say that, again, given the status of the Texas court and the Fifth Circuit and the Supreme Court, is an appeal going to happen? Yeah, maybe. Now with the, again, outcome of the election, is the reversal likely? Probably not. So make sure that you align your compensation practices with these current legal standards, and be prepared for a little heartache if you are going to walk those back. Little bit of an OSHA update, not too much to worry about. One of the things that OSHA and other state similar state agencies have been working on are in response to climate change and warming climate issues. So back on July 2nd, OSHA announced a rule regarding heat illness and injury prevention. I think that the rule, very similar to what we've just, the FTC, the Department of Labor, I think that those rules are likely to face legal challenges. So we need to keep an eye on this rule, but essentially, this rule will kick in when an employee is exposed to temperatures of 80 degrees for more than 15 minutes in a 60-minute period. The rule does require that a company adopt a written prevention plan and put in place heat injury related precautions, cool down breaks, water breaks, providing shade, things like that. The rule also requires training and regular program reviews and updates. So it isn't necessarily all that easy to be ready to comply with this rule, but it is likely to potentially face these challenges similar to the other agency actions. Okay, so the NLRB, again, we almost never talk about the NLRB, but Jennifer Abruzzo, the general counsel, she's probably out with the new administration that's going to be coming in. And I would expect that just like we did when the Biden administration came in and the pendulum swung more left and leaning and more employee friendly, with the Trump administration coming in, the pendulum will go back to be more conservative and more employer friendly. If the board survives at all, it's very open. However, I do think it's still worth discussing the NLRB's recent memo that they issued regarding stay or pay provisions. So stay or pay provisions are those, they're stay or pay or TRAPS, which is great. A great acronym, training repayment agreement provisions. These are agreements that require an employee to repay costs if they do not stay with their job for a certain period of time. These are super common if a company is going to advance educational costs, help an employee, through a graduate program or pay for other training costs. And when the company tries to recoup that investment by having the employee agree to stay on for a period of time or be trapped for a certain period of time while the company is recouping that investment in the employee. And again, these are super common, and you might be sort of thinking, oh boy, I have one of those. Well, of course you do, because we here at WFJ, we have reviewed a lot of these for our clients, and up until now, they've sort of flown under the radar. Well, now the NLRB through Jennifer Abruzzo has issued a memo stating that these types of agreements potentially violate an employee's Section 7 rights under the National Labor Relations Act. What is that? And again, this is one of those provisions that applies to your company, whether you've got a unionized workforce or not. Section 7 rights are rights that all non-supervisory employees have to band together with their other coworkers to fight to improve the terms and conditions of the workplace. So improve wages, improve safety, improve health, all of those things. So what the NLRB position is that when an employee is trapped by one of these stay or pay agreements, they may feel like they do not have the power to engage in Section 7 rights. Like if you know that you're going to get terminated and you're going to have to pay back thousands of dollars in educational costs that your company paid, maybe you aren't going to join in on the day that you guys are going to strike or picket, or you're not going to be part of the signatory to an email to the management team demanding higher pay. It's saying it's chilling those Section 7 rights. And what this means is that in order for a stay or pay provision to be determined to be lawful, employers are going to need to think about how this guidance affects those agreements. And so you've got to look at, is the stay or pay, they're not outright banned. It's not the non-compete ban, but you've got to look at these stay or pay provisions that you do have. And if they do not meet all four of these tests here, they're potentially an unlawful stay or pay provision that could lead to an unlawful practices charge, unlawful labor practice charge by the board. So the provision has to be voluntary. The employee has to freely agree without any undue pressure or financial consequences for opting out. The stay or pay provision has to reflect the actual cost that the employee needs to repay. So if your company pays for an employee to get their CDL and the CDL course is $1,000, if you're trying to recoup $10,000, well, that doesn't reflect the actual cost that the company is out. It has to have a reasonable stay period, and that duration is going to align with the value of the benefit that you provided. So if it's a couple $100, the duration can't probably be 2 years. If it's, tens of thousands of dollars because you're helping somebody get a graduate degree, then maybe a 2-year period or even longer might be warranted. But there has to be some alignment between that stay period and the value of the benefit that you provided. And then if you terminate without cause, so you're using the at-will, except for Montana, statutes in your state to terminate an employee without any cause, then you can't apply the stay or pay provision. If the employee voluntarily leaves or you terminate for cause, then potentially you can recoup that money. But if you're terminating without cause, then you can't require repayment in those circumstances. This memo did give a 60-day compliance deadline, but because of the timing, you only have 2 more days to modify any non-conforming agreements by December 6th to avoid enforcement action. Well, again, if you're sitting there and you're going, well, wait a minute, Trump administration, January 20th, it's December 4th. What should we do here? That is a business decision for you to make, and it's got to be based on your relative risk tolerance. Is the risk huge that you're going to be, the NLRB is going to be knocking on your door because you have one of these? Probably not. I think if you're looking to enforce one of these agreements by deducting from pay or something like that, maybe that is when you consider, are we going to enforce this or not? And then see what happens January 20th. Now, it's not probably the case that just right away on January 20th, this stay or pay provision memo gets knocked down. I can't say that for sure, but it could take some time. Like I said, this swinging pendulum, it does take a little bit of time for things that were done under a Democratic administration to sort of go back to being, the way they were done under a Republican administration. So there's some strategies here. Even if you are, it still might, even if this memo does get struck down, which I think eventually it probably will, you may still want to go back and look at, does it still, just for morale, workplace recruitment and retention, and because we generally like our employees and respect them and care about them, maybe you do want to go back and modify any overly restrictive stay and pay provisions, just in case this law does stick. So, all right. My coffee. So, any questions that came in yet?
No questions as of right now.
Sophie?
Oh, yeah, no questions as of right now.
Okay. Oh, okay. I couldn't hear you.
Yeah.
All right. Perfect. All right, so here is our whirlwind, go as fast as we can part of the presentation. So I am sorry for this, but it's the only way to do it. So I'm going to hit the high points for you guys. You'll have the slides so that you can go back and re-review. You could always reach out. But what I did was I wanted to make sure that everybody had an overview of kind of what's been going on in anticipation of the coming year. So the California Supreme Court, California, always a thorn in our side, reversed a grant of summary judgment for an employer, and they held that just one isolated single use of the worst racial epithet that you can think of, and if you're thinking of the worst you can think of, you're probably correct. One use can be sufficiently severe to create a hostile work environment claim under California law. That is a very significant case. Most jurisdictions that are not California or the Ninth Circuit are going to say an isolated or single use is not enough, but California and Ninth Circuit is probably going to say that one might be enough. So this is really going to change that calculus and that analysis of whether a hostile work environment has been created by even a single use. I've seen cases in the Eighth Circuit where an employee, a Black employee, was subjected to, they hung a noose in a warehouse. There was a few instances of the use of the N-word, and that was still found not to be sufficient for a hostile work environment. So this is a big change, and something companies that have employees in California or that operate there need to know. Cal OSHA also, or the Office of Administrative Law, approved Cal OSHA's safety standards for heat illness prevention in indoor places of employment. So if an employee is working indoor and the temperature gets to a certain point, there's this heat illness prevention program that companies need to adopt, very similar to what we just talked about from OSHA. Governor Newsom had signed into law a law requiring that the California Labor Commissioner develop a template poster about whistleblower protections, and employers are going to have to post that model notice. So just be aware that that is something that you will need to now post for those California employees. There now is an amendment to the California Labor Code that requires that employers include information and notices related to work comp rights and benefits, that an injured employee has a right to consult an attorney. So this takes effect January 1st. So if you've got you got to look out for that. If you have to include that information that they have the right to talk to an attorney, which of course is going to make employees talk to attorneys, which is the purpose of that. The California Civil Rights Council announced a proposed rulemaking to address employment discrimination under California law arising from the use of automated decision systems. This is AI. So if you're using AI to sift through hundreds of different resumes and you're using it to help you make hiring or other employment decisions, they are going to be making some rules to address discrimination that's caused by that use of AI. You'll see a trend in that. And there's also been we've seen some privacy type of lawsuits in California where companies were using chat, like note-taking features, AI note-taking features, and being sued. So we have to be very cautious with in our companies what we are doing with AI until we can kind of figure out what we're doing with this. This is actually kind of a sort of bright silver lining maybe piece for companies. California Supreme Court held that an employer's reasonable good faith belief that it satisfied wage statement requirements is a defense to claims for penalties or damages that the employer gave an inaccurate wage statement. This is silver lining. I'm not going to say it's platinum lining, because if you're arguing about an objectively reasonable good faith belief, guess who you're arguing about that with? You're telling a judge or a jury about that. So you've probably already sunk some cost into getting to that point, but still better than it was before. Colorado, been very busy. There's the Colorado Privacy Act was amended to broaden protections for biometric data. So if your company is using a fingerprint scanner, a retina scanner, if you're super fancy, or some other type of biometric information for access to your building or for timekeeping purposes, you've got to know that there's additional protections for that information that were added this year. Hair length that is commonly or historically associated with race has been added to the Crown Act, which prohibits discrimination on the basis of hair, of your hair. And so hair length is now added to that. There's also this Care for Living Organ Donors Act. It includes a provision that prohibits an employer from intimidating, threatening, coercing, discriminating, or retaliating against an employee 30 days before and 90 days after that employee becomes a living organ donor. And I would just say probably it's not great HR practice with or without this law to threaten or coerce or intimidate a living organ donor. But, sometimes there's a reason we got to write things down sometimes. So somewhere somebody did these awful things and now they are prohibited specifically in Colorado. Here we have another issue related to those TRAPs, those training repayment agreement provisions. New protections were added in Colorado for any employees that are subject to those. So those are in addition to what has been voiced by the NLRB. So you've got to look at those agreements if you have employees or operations in Colorado. Connecticut, they expanded their paid leave law in the state effective January 1st. The new law, it expands which employees are covered, the reasons that they can take this paid leave, changes for how the leave allocation is calculated. Then they also added that between 2025 and 2027, the law is going to be expanded to cover all employers. And so I believe at this point, it is only employers of a specific size, and that size is going to be changing over this course of time. Also, 2025, we will start talking about, we get lots and lots of questions from our Minnesota clients. When are you guys going to give us some education on Minnesota paid family and medical leave? When are you going to help us with this? We will. We will be doing webinars in 2025 to get everybody ready for Minnesota paid family and medical leave as well. We are going to now have a split legislature, though. And so, there could be other changes that are made to that law before it goes into effect. We've already seen changes being made. So just, I always, anytime I bring up paid family and medical leave, everybody always wants to say, what's Minnesota doing? I don't know yet. And so stick tight on that. We will get you training on that. So not to worry. In kind of an interesting sort of reversal of what normally would happen in Florida, the court in the Northern District of Florida permanently blocked Florida's Stop Woke Act, and that restricted the types of anti-harassment and anti-discrimination training that employers could require their employees to attend. So if you were conducting anti-harassment, anti-discrimination training in Florida and you were worried about that Stop Woke Act, don't have to worry about that anymore. That is permanently blocked. Hawaii, if you are you or your employees are very, very lucky to live in Hawaii. Effective on June 21st, the law was amended to increase the minimum monthly salary employees had to earn to $4,000 to qualify for the monthly salary exemption from the Hawaii wage and hour law. So federal salary thresholds can continue to get ping-ponged around and passed and revoked and passed and overturned. States are implementing these. And again, I think that with the change in the administration, it is only going to heighten the number of states that we are seeing that are going to pass. Illinois was very, very busy with their legislative session. Lots going on here. If you are an Illinois employer that has day and temporary labor services, there's some clarifying language that was added to that. So take a look at it. It's kind of complicated. It eats up, as you can see, it eats up a lot of that chapter there, 175.1 to 175.99. So just be aware if you are using day and temporary labor services in Illinois that there's some changes that were made. They also amended the Human Rights Act to prohibit discrimination based on an employee's family responsibilities. So they have to care for a family member, things like that. They also amended the Construction Industry Employment Freedom Act, and it prohibits non-compete and non-solicitation agreements with individuals employed in construction effective January 1st. So here again, we see that the Federal Trade Commission rule gets struck down, but then the state comes in and says, actually, you know what? For anybody working in the construction industry, non-competes and non-solicits, those are banned. So if you are in that industry in the state of Illinois, please review and make sure you understand the limits to those agreements. And that is effective January 1st as well. The Whistleblower Act was amended as well to prohibit retaliatory action by employers against whistleblowers. That protection already existed. It's codified here and it's more specific. So look at that. The Personnel Record Review Act was amended as well. It requires employers to maintain copies of pay stubs for 3 years and provide those pay stubs to former employees within 21 days of request. So just like we see trends on the non-compete front, I'll tell you that these pay equity and pay transparency statutes are becoming just as popular, just as prevalent. And so you'll see again a theme here of what's been going across a bunch of these different states. The Illinois Human Rights Act was also amended to prohibit discrimination based on reproductive health. So that is reproductive health as far as IVF and use of birth control and things like that. Then August 2nd, another very busy day for Governor Pritzker. The Personal Records Review Act again amended to include specific documents that employees have a right to look at, copy, without fees. So again, if you have operations in Illinois, employees in Illinois, know what those documents are, what the changes to that, and what documents you will have to provide free from charge. The employment article of the Human Rights Act was amended. If employers will violate the act if their use of AI for recruitment, hiring, blah, blah, it creates an unlawful discrimination situation. So again, another ding against AI. If you're using AI to, comb resumes, figure out who you're going to interview, make offers to, etc. If there is any unlawful discrimination in that process, then you are going to be violating Illinois' Human Rights Act. I don't know how, but so Illinois has one of the most extensive biometric privacy acts in the nation. It's the Biometric Information Privacy Act. It's been there for a long time. If you're doing hand scans, fingerprint scans, retina scans for any employment purpose, the court recently, or the legislature recently, changed how they're going to be calculating those statutory damages. So just if you are doing that in Illinois, make sure you've got a biometric information privacy policy, that you're getting authorization from your employees before you start collecting that data, etc. And because cities like to really get in the mix now too, and have for a while, the final rules regarding Chicago's paid leave and paid sick and safe leave ordinances have been published. So it's meant to guide and help interpret these rules for employers. Are they helpful? They're okay. Could they have done worse? Sure. Could they have done better? Yes. But just know that those final rules are there, and the helpfulness sort of ranges. Here's a state we very rarely talk about, Louisiana. 4 new laws took effect this summer. One expanded the statute of limitations for employment torts, and so employees have a longer amount of time to bring employment-related claims. There was laws relating to meal breaks for minors. There was a ban on pre-dispute arbitration agreements for sexual harassment. So before you go to arbitration, if it's pre-dispute arbitration agreements, and you're going to basically say that, all employees have to arbitrate any claims of sexual harassment before the dispute arises, those are banned. There's also a ban on non-disclosure agreements regarding sexual harassment or hostile work environment claims. So if you enter into an agreement with an employee who is alleging sexual harassment or a hostile work environment, that agreement cannot contain a non-disclosure agreement. You can't tell that employee that they can't discuss the facts that led to the case. So that, again, this has not been the trend I thought it would be, but several states have gone down this road. So Louisiana just happens to be one of the newest ones. They also enacted a law rendering unenforceable an employer-required non-disclosure clause that's agreed to prior to a hostile work environment dispute or a sexual harassment dispute. Again, this is meant to protect employees who are alleging a hostile work environment or sexual harassment. So if you're in Louisiana, you have employees there, please be aware of those. You may need to have those agreements reviewed and modified accordingly. Massachusetts, announced a new law on salary range transparency. So, yep, Massachusetts salary transparency, very much a trend. Companies that have at least 25 employees have to disclose salary ranges on job postings. And it protects an employee's right to request a salary range if you've not provided it. And so again, the fear here is that by publishing salary ranges, if you've got employees, especially existing employees, who fall outside that range, it is going to potentially lead to pay equity lawsuits. So this was effective this summer. So if you haven't already and you are of a certain size with your operation in Massachusetts, you need to look at this because those salary ranges are required to be posted. Interestingly enough, the Michigan Supreme Court did reinstate Michigan's voter-initiated Improved Workforce Opportunity Wage Act and the Earned Sick Time Act. And so these laws expand paid sick leave available and it increased Michigan's minimum wage rate. These were things that voters voted on, and the Supreme Court went ahead and reinstituted those. Those take effect February 21st, 2025. Here, I don't know why that date, but there you go, February 21st, if you have Michigan operations. All right, Minnesota, because we couldn't just give it a rest after 2023. We still did a lot in 2024. We amended the state's pregnancy accommodation law and pregnancy and parental leave law. That has already gone into effect. Amendments were made that to state that shared gratuities law that requires any tips or gratuities received by credit card be credited to the employee in the same pay period in which they were received. So if you've got tipped employees, definitely make sure you spend some time wrapping your head around this law change. This is an interesting one. So Minnesota has one of the most difficult to comply with drug and alcohol testing laws. And if you didn't know that, write that down. If you're doing drug and alcohol testing in Minnesota, there are a lot of things that you need to know about. Minnesota legislature is now going to allow employers to use oral fluid testing. Sounds gross, and it's just exactly what you think, spit test to essentially determine whether there's drug, alcohol, or cannabis on the employees. So you can do this without requiring a testing laboratory as an alternative method. This, I think, will be really helpful for companies that have swing shift, second shift, third shift, where maybe drug testing facilities are not going to be open at that time, but you've got reasonable suspicion and employees on the premises under the influence. So if this sounds at all interesting to you, there's a lot to know again about that. So reach out, we can talk about that. Great. Increased powers to the Department of Labor to investigate and remedy complaints. I love that. Not too surprising. Governor Walz did sign a bill that amends the Minnesota Human Rights Act, and it expands the definition of protected classes. So again, something else to be aware of. Like we were trying to talk about last month, there were significant changes to the Earned Sick and Safe Time law that came just 6 months after the statute took effect. So still wrapping your head around it. They come in and make even more changes. Watch for the re-recorded video of that training. That'll be coming out here shortly. There were also some significant changes in classification of workers as independent contractors or employees. This is specifically for construction workers and those working in the construction field. But there was essentially increased penalties for misclassifying employees as independent contractors. And they updated the test that is used to determine whether a construction worker is an independent contractor. And the test, it's got like 15 subparts. It's very difficult now in Minnesota to classify a construction worker as an independent contractor. So if you are doing that, please make sure that you are again, wrapping your head around these law changes. And there's more. I hear you, Sophie. I'll get through this slide and then we can take that question. The lower minimum wage tiers for small employers are going to be eliminated starting January 1st. Same with the minimum wages for employees under 18, employees on J visas, etc. So know what those minimum wage changes are that are coming into effect. Employers that have 30 or more employees in Minnesota have to include pay range or a fixed pay rate in all job postings. So here's some more salary transparency. There are some service contract act changes. So I don't have time to get too much into this, but if you are restricting service providers from working with, if you're in staffing and you're restricting them from hiring any of your employees or independent contractors, you've got to be aware of this provision. And then you've got to keep current and former employee earning statements or pay stubs for 3 years now. Okay, Sophie, what's happening?
Hi, thank you. Yes, so 2 Minnesota clarifications. So the first is about these salary ranges. So the client is wondering if they have to put the whole range if they never typically hire at the top of the range. So example, should they be posting 40K to 60K a year if they don't ever hire an employee for more than 50K?
I mean, if you are never going to, it has to be a realistic salary range. So if you never hire over 50 and you're not going to, then it should be 40 to 50. Because
And do they, and that the clarification too is they want to leave room for growth. So if that's why they have the up to 60, but they don't necessarily bring a new hire on at 60, but they want the range there for growth.
I mean, it's to be the starting salary. That's what it's to be that range of that salary. So of course it could change, but I would say if you do have growth and you do get employees into that higher wage range, you're going to need to consider updating what you're posting. I'll give an example for you. A school that we work with, they hire teachers and they might have 1 year of experience or 25 years of experience. They'll take somebody with 1 year, they'll take somebody with 25 years. And that wage range is massive. And so the question is, well, it's such a huge range, like, do we have to post that? And the answer is yes. So if it's 40,000 to 180,000, you've got to post that range. That is just, it's unfortunate. And then you just say it's depending on experience. And then you have sort of that flexibility built in.
Okay, thank you. And then the other Minnesota question we got, you generally mentioned earlier about the paid Minnesota sick leave that we will address the closer we get to 2026. It was about specifically announcements and notification requirements, and that's something that we're not going to address today. We'll address when we get closer, right?
Yeah, I mean, the reporting requirements is already open, so you do need to be aware that the reporting requirements to DEED are now open. But as far as all of the other details, and this is paid family and medical leave, not ESST is different, but yes, for the paid family and medical leave, we're not going to get into it today because, like I said, the legislature has already changed the PFMLA. And so what could happen between now and January 1st, 2026 is so wide ranging that it does not make sense for us to sit down and start talking about this. But yes, there are reporting provisions that did open up this fall. That's the only thing at this time that I would say that Minnesota employers need to be really worried about.
Thank you so much. That's all for now.
Okay. Couple more states here. We'll just kind of hit the high points. New Hampshire joined the Crown Act craze and has passed and created a private right of action for discrimination based on hairstyle. So employees there can bring a private lawsuit against their employer. The New York State Department of Labor published some materials regarding a mandatory model policy as it relates to lactation breaks. And effective this year, employers in New York have to provide 30 minutes of paid break time for employees to express breast milk. New York City is prohibiting employment agreement provisions that shorten the period of time that an employee has to bring discrimination civil action. So it basically just shortens that or prohibits shortening that amount of time. Pennsylvania is the first statute imposing limitations on the use of a non-compete agreement with healthcare practitioners. So again, more disfavoring of non-competes. If you're in Pennsylvania and you're in the healthcare space, be aware. Rhode Island has enacted some new laws regarding temporary caregiver insurance leave, minimum wage, overtime protections. They also are prohibiting an enforcements of non-competition agreements with advanced practice registered nurses. Not as broad as Pennsylvania. It is more specific, but again, more hate on non-competes. South Carolina, they have signed a bill into law that legislates earned access wage products. These are things that allow an employee to access their wages before the standard payday. Nevada's done it. Wisconsin did it. Again, it's not maybe necessarily a bona fide trend yet, but we're looking like we're heading there. Vermont has signed a new pay equity law that requires employers disclose compensation in job postings. So if you've got 5 or more employees in the state of Vermont, you've got to post that pay range. And again, I do think that that's going to continue. And so definitely makes sense to spend some time, especially, for a lot of you who have Minnesota employees and are going to meet that threshold employee count number. Spend some time on this. Look at what your pay ranges are. Get prepared for this law, because what you don't want to have is you don't want to be posting salaries and then then now you're facing down a pay equity audit. So you got to look at those, address any inequities now before you start having to publish these. And do I think that on January 1st, there's going to be a flurry of lawsuits in Minnesota that, hey, you didn't publish this pay range? Probably not. But if you're a flagrant, violator of that law, and you've been warned and you've been told, I do think that you could be fined for that. So this pay transparency stuff is definitely a trend. I think we're going to see lots more states passing those with the change of the administration. Thank you so much for attending today. Technology done. So I hope this will look for those slides. I know that the state law update is always very fast to go through, but you can always reach out to us. If you are using the Compliance Center, you can also reach out to Chris if you don't already have access to it and you'd like it. So I hope you all have a wonderful day. Thanks, Sophie, for moderating, and have a great one.